943, 944. State of Wisconsin, Cody Burnett versus Blake Hansen. The state appears through Assistant District Attorney Jose Vila in person. Mr. Hansen appears in person with his counsel, Joel Feliski. We're set today in this matter for status conferences. However, the court's been updated or informed that an agreement has been reached. The court has approved changing the status conference over to a plea and sentencing. Mr. Feliski, please inform the court of the agreement that's been reached.
Thank you, Your Honor. Mr. Hansen has agreed to plead to both counts in 25 CF 168. On count one, the parties are making a joint recommendation for a deferred judgment of conviction agreement. On count two, the parties are making a joint recommendation for a fine inclusive of court costs. I apologize. I'll correct the record. It will be for court costs only on count two. I've gone over a completed plea questionnaire and waiver of rights form with Mr. Hansen, along with the deferred judgment of conviction I referenced with him as well. May I approach?
You may. Thank you. Thank you. We will go on the record, or we are in the record, and Mr. Hansen, I have in front of me two documents. Do you recognize these documents?
I do.
Did your attorney thoroughly go over these documents with you?
That's correct.
Essentially word for word?
Yep.
And you understand everything on these documents?
Yes.
If you didn't understand something, did you ask your attorney to explain it to you until you did?
I did, yes.
So you understand everything?
Yes.
And did you sign these documents?
Yes.
You are 22 years old, 11 years of schooling. You do not have a high school diploma or equivalent. Why not?
There's a lot of moving around. So in 11th grade, I moved from Grantsburg to Kankakee. It's roughly 45 minutes south of Chicago. Moved in with my Aunt Jamie. Things didn't end up working out too well down there. So moved back up here. I gave that another try. And ever since then, it's been job to job. And the previous incidents, then went to a sober house. I got my priorities straight and just trying to fix what I messed up.
Okay. And do you have any intention on trying to get that GED or HSED?
I do indeed. I'm going to call up GHS after this session here, see if I can go and grab my transcripts and I can turn them into a community college down in River Falls. They do a free GED program and stuff like that. So
That's what I was going to say that I want you to do. And they have, it's the same community college, and they have a 2-week kind of boot camp.
Yep.
Where you can do it, and that's what you're looking at doing?
I was.
Excellent. You're making me happy because you're 22 years old, haven't talked to you much, haven't really seen you much on these cases, but you seem like a smart young man. You should have at least a GED or HSED.
Yes.
I think you can't get an HSED because you have to have a physical education aspect, but I'm not quite sure. I'm glad to hear that. Thank you for letting me know that.
Most definitely.
So you can read, write, you understand the English language, and did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
And he went over the maximum possible penalties you face?
Yes.
No medications, no illegal substances or alcohol, and you aren't receiving mental illnesses, or you don't have mental illnesses or disorders?
No, ma'am.
Excellent. Because you're charged with crimes, you're entitled to constitutional rights, and those rights are listed on both of these documents. You understand those rights?
Yes.
They were thoroughly explained to you?
Yes.
Do you need me to go over these rights with you in any more detail?
If you would like to, but no.
But you understand them?
Yes.
So I don't need to?
No.
Okay. Do you understand that once you plead guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that with regards to the plea or attempt to, the state would have to prove on or around November 8, 2025 in Burnett County, Wisconsin, while operating a motor vehicle on a highway after having received a visual or audible signal from either a traffic officer, a federal law enforcement officer, or a marked or unmarked police vehicle that you knew or should have reasonably known was being operated by a law enforcement officer, you knowingly fled or attempted to elude that traffic officer by willful disregard of the visual or audible signal so as to endanger other vehicles. Do you understand what the state would have to prove?
Yes,
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
I do. Yes,
You understand with the paraphernalia, the state would have to prove that same date, that same time, that same place, that you knowingly possessed with a primary intent to use a gem baggie to store a controlled substance. Do you understand what the state would have to prove?
yes,
Do you understand the maximum possible penalty could be a fine of no more than $500 or no more than 30 days of incarceration or both?
yes,
Do you understand the agreement that's been reached as recited on the record?
I do.
Do you understand I'm not bound to follow that? I can sentence you to what I may feel would be an appropriate sentence, even if it's not that agreement. Do you understand that?
I do. Yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Now, did you go over the facts that are alleged in the criminal complaint of what you may have done that day and why you were charged with the crimes with your attorney?
yes,
For the most part, are they accurate?
yeah,
So you're pleading guilty today to the attempt to flee and elude an officer because you're guilty of that? Did you do that, or would it rise to that level? You can talk to your attorney.
yes, Your Honor.
Are you pleading guilty to the possession of a drug paraphernalia because you're guilty of that?
Yes, Your Honor.
Mr. Polisky, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
So stipulated.
Has anyone made any threats or promises to you, Mr. Hansen, for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly,
yes,
discussed the discovery, the evidence with you?
Yep.
And any defenses you may have or a lack of defenses?
yes,
Are you satisfied with his services?
I am. Yes,
Any questions for the court or your attorney before I proceed?
I do not.
As to count one, attempt to flee or elude an officer, how do you wish to plead?
Guilty,
As to count two, possession of drug paraphernalia, how do you wish to plead?
guilty,
Court will find your pleas of guilt are done knowingly, voluntarily, and intelligently. It will find that you understand your constitutional rights and what it needs to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those two charges. Enter judgment as to possession of drug paraphernalia. Stay on entering judgment and/or wait until I hear arguments. Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation in this case is appropriate. This is a case where Mr. Hansen was being pulled over by law enforcement and siren. He did not pull over and he led them on a short chase through town, going around many sharp corners at a high rate of speed. Given the fact that Mr. Hansen is a relatively young man, he has no felony convictions on his record to date. I think the deferred would give him an opportunity to earn his way out of a felony conviction on his record since he is young, and also give him the chance to pursue that AODA, which it sounds like is necessary for him to get back on the right track. Related to the drug paraphernalia for court costs, I think that's more than appropriate given that it's a very low level offense in the grand scheme of things. With that, I would ask the court to adopt. Thank you.
Thank you. Mr. Polisky.
Thank you, Your Honor. I'll first note the credit for Mr. Hansen. He believed he was brought in custody on these charges on the date of the incident, November 8th. He then posted bond according to the CCAP record on the 17th. By my math, that would be 9 days of credit. Your Honor, I concur with many of the statements made by the state. Mr. Hansen is a young man. He acknowledges that this was a very foolish decision on his part, but he has been doing a substantial amount of work in the time since this has been happening, actually even before this case initiated, towards addressing that issue, as he advised that While in custody, he made plans to go to Onyx Sober Living in Menominee. It's my understanding that he did enter into that program and successfully completed it. Again, this was all prior to his initial appearance on this matter. As he indicated to the court, he is working on getting his GED. Sounds like he'll be following up on that today. I think the agreement that the parties have reached here, Your Honor, will keep Mr. Hansen accountable. He's got a very big ticket item here, which is avoiding a felony conviction. I think abiding by the conditions here will address any of the concerns that may have caused or catalyzed or otherwise caused this incident to occur. I think the AODA assessment will allow him to address any of those issues. I think overall that this is a appropriate agreement. I think it protects the public. It addresses Mr. Hansen's needs, and it's appropriate given the nature of the offenses here. I would ask the court to follow the agreement. Thank you.
All right, thank you. Expunction,
Your Honor, I believe he is eligible for expunction.
any opposition,
No, Your Honor.
argument for why?
Your Honor, Mr. Hansen, again, is a young man. He's taken steps even prior to representation to put himself on a better path here. I think this incident, while regrettable, certainly, and serious in the level of the offense charged, I think it doesn't necessarily reflect who Mr. Hansen is as a person. As the court indicated, and in my conversations with him, I do think he is a very smart young man. I think that he made a poor decision on this day, but I don't believe that that decision should hang over him. I don't think that it should be what tells his story going forward for the next 10, 15, 20 years. I think expungement in this case would be appropriate. Thank you.
Mr. Hansen, anything else you want to tell me, you want me to know, you want me to think about and consider?
I would say aside from going to Onyx Living and getting my GED and taking all the right steps forward, at the moment, I do not.
Okay, thank you.
You're welcome.
Well, I have to look at certain things, the seriousness of the crime. I have to look at you, your character, your history, all of those things. And then I have to look at a need to protect the public. Are you a threat to the public? Okay, and I think this is serious. Count one is definitely serious. You put yourself and others in harm's way. Count two, looking at you, your character, you seem like you may have had a little rough start in life or a little instability at times. And so you were not able to get your high school diploma, but you want to achieve that. You want to be better and have a better life. So I appreciate that. I don't think you're a risk or a threat to the public. You seem like a nice young kid who did something really stupid. Yes. And you're admitting that you did. And you're shaking your head up and down because it was a stupid day, stupid choices. But choices, although you have to be accountable for them, they don't have to define who you are. And they don't have to control the rest of your life. Okay. I think that the deferred judgment of conviction is appropriate. So I will adopt that and receive the deferred judgment of conviction. As to count two, possession of drug paraphernalia, cost only is appropriate as well. I'm assessing $350 fines, fees, DNA surcharge for the possession of drug paraphernalia. I'm waiving the rest. Here's why. You have $500 posted. You need $150 to pay for this handy dandy little agreement that you worked out with the state, with the district attorney's office. I am directing my clerk to transfer $150 from the cash we have over to the district attorney's office to take care of that condition for you. Alrighty. It's off your shoulders. Then you don't have to come up with another $150 within 60 days. I'd rather have you concentrate on your GED. And here's another thing. I accept the deferred judgment of conviction, but not as presented. I have put my own two conditions in this agreement. You will get a copy. You will know what you need to follow. First condition, you know that this lasts for a period of 12 months. All right. First condition, you complete your GED program and attain your GED or equivalent by the time this is done, a year. Okay. And the other thing I added is I'm going to allow you to expunge this whole case. It'll go away. No one will be able to see it again. So, because if I don't, even if I expunge count 2, count 1 would still remain and people can see that you were charged with that and yada, yada. I want this to be hidden from everybody. If you do what you need to do, you follow this and you meet all the conditions,
Yes, ma'am.
okay? Because I think you're a nice young man. I do think that you're smart. You've trying to put everything back on the right path, your GED, going to Onyx House, taking control of any substance abuse issues that you have, then getting a job and doing those things. So I think having expunction of the entire case will benefit you. It won't harm society or the community because you'll be in a better position where people won't go, oh, he got charged with fleeing an officer, you know, or attempt to flee an officer, because people can still hold that against you, even if it's dismissed, because we have this lovely thing called the internet and CCAP,
Yep.
which holds all of our records, our criminal records, all our court cases, all of those things for like 75 years. So you do all that you need to do. You abide by all of these conditions within the timeline required, and including getting your GED. And not only will the matters go away, but they will be completely expunged, and you will be on a better path.
Thank you.
So that's what I want to see. So I think you're good to go. You have 20 days to appeal. If you fail to appeal within 20 days, you do lose that right. I do have an updated address now. Thank you. It says River Falls. I thought you said Hudson.
I thought it was Hudson. Yeah, that was an error of mine, Your Honor.
Okay. Telephone ends in 3904.
3904, that's my dad's.
Do you have one?
I do 534-356-1692, I believe. It's a new phone number of mine, so
Okay, here's the deal. Once we're done here,
yes.
go out to the hall, double check that's your number. If it's not, then talk to a clerk in the clerk's office and give them your correct number,
Alrighty.
okay? Because we need that information, all right?
Alrighty.
And so you're on Maple Street?
That's correct.
Excellent. Okay, so 20 days to appeal. I need your DNA at least for the paraphernalia. So when you're done, you need to go to the jail, day reporting all the way around the back of the building and provide your DNA. This is something you can request, have your DNA expunged from the CODIS system. Are you familiar with that? But the whole worldwide, not worldwide, but our United States wide system that keeps DNA. So if you want to have that expunged, removed from that system, you can, but you have to ask the Department of Justice through a written letter. You don't write it to me. You don't write it to the court, to the Wisconsin Department of Justice. It's easy to do. Google it or ask Mr. Flisky and he can help you, okay?
Alrighty.
All right. I think I got everything, Mr. Vila.
The 9 days of jail credit,
Oh.
Your Honor.
Well, he wouldn't need it unless they sentence him to 9 days of jail. So I will too. I'll add 9 days of jail for the paraphernalia. You sat him, might as well get credit. Okay. Actually, no, don't do that. I don't want it to interfere with any kind of expunction ability. So, sorry, you sat it. You're punished, probably appropriately,
Yep.
and you're going to change your ways, right?
Yes.
All right, anything else?
Not from my perspective, Your Honor.
Nothing further.
All right, thank you. Then we are adjourned.
I'll go get a copy of this real quick, but I have to do it out there. So if you want to meet me at the clerk's office.